Thanks for joining us on the show today. Myself, Tesh Patel, and Claire Matson today will go over a couple of frequently asked questions. I am an estate attorney at Cohen Pollock Merlin Turner, specializing in estates, trusts, and administration thereof, as well as tax planning.
And I also do estate planning at Cohen Pollock Merlin Turner, and I also focus on probate and estate administration.
Well, Claire, I thought today we could discuss just some of the frequently asked questions that we get from our clients. The one that I got more recently is, how do I change residency? A lot of clients want to move usually to Florida for income tax reasons, and they are wondering if there's just a simple form that they need to complete to show the state of Georgia that they no longer reside here, or what. And so I tell them, typically that it's not just some simple form or anything like that, but it's rather a number of steps that you take to support the fact that you change domicile. And usually that includes voter registration, updating your estate documents, obviously, paying property taxes down there, and just registering your children to be in school down there, whatever it might be. But it's, and all of these are indicia of having transferred your domicile.
What about people who split their time between Florida and Georgia? Do they need to pay more attention to the number of days in either state, or is it really the things that you mentioned?
Good question. And so it's all of those things, but also you want to spend more time in Florida than you do in Georgia.
I mean, who doesn't?
That's right. Warmer weathers and all that, right? So, but yes, so you want to act as though and hold yourself out as being a full-time Florida resident, only visiting your former state for vacation or just to see friends or family or something like that. So everything else, you should have all of your mail delivered to Florida. You should use that as the primary address on your federal income tax returns and so forth.
Well, to that end, I get the similar question of when I do change my domicile or my state, or when I move, how do I deal with the documents that I've spent money on establishing in my former state? And what I tell people is that all the documents really are honored from state to state. If you move in December and you don't get your new documents until later in the next year, it's not that you're going to be without documents, but you would probably be better served by having those documents reviewed by an attorney who's licensed in your new state, as well as updating, in particular, the powers of attorney and the advance directive for health care, because those very often vary greatly from state to state. Other estate planning documents, revocable trusts, and wills, again, are typically honored between multiple states, as you know, but as you know, by being licensed in multiple states, state law varies greatly from probate matters and trust matters and administration powers that executors can have. And if you have documents in one state that don't have the powers that might be better for you, that are available under your new state of residence, you're really doing a disservice to your family. So even if it is an expense you weren't anticipating with relocation, it'll be better for you and your family if you at least have those documents looked at by the right attorney in your new state.
Yeah, do you have any? I had, for instance, a situation recently where it was a foreign will, right? A will that was done. It was valid at the time that it was done in another state and so forth, but admitting it to probate here because the self-proving affidavit is not exactly...
Right, because that is definitely something that's different from state to state. Georgia's requirements for that are very particular, and if you don't have those particular magic words in the self-proving affidavit, then you are required to locate those witnesses that may have signed that will as witnesses 20 years ago. So it's very burdensome to have to meet those standards if you don't have the right words in your documents. There are provisions in Georgia law that allow an executor to waive or to be waived from having to provide inventories and accountings, and those aren't available in other states. And if you have a Florida will that doesn't have that, your executor may have to have extra reporting to the probate court that wouldn't be necessary if you just had updated your documents. So that's an important thing to consider.
Right. And on that note, do you ever have clients that move down to Florida and just decide to sort of leave their documents in shape or anything like that?
All the time. People don't want to redo documents, and I think that causes problems. On the other side, if they're going to a state that requires different types of signing formalities, their documents might not be valid in the new state because it doesn't have the right things in it.
Well, as a Florida attorney, I want you to at least remind those clients of a couple of things, okay? When it comes to the powers of attorney, like you mentioned before, Florida's power of attorney or financial power of attorney is not springing, okay? And as you mentioned, the financial custodians are just more accustomed to seeing the local forms there, so they should go ahead and redo it. But unlike Georgia's, that one is not springing. It's effective immediately, and you can't really work around that. For personal
That's interesting.
assets. Another thing is, and this comes up in a lot of states actually, is when you redo the Georgia healthcare directive in Florida would be designation of your healthcare surrogate, living will, and so forth. I have a lot of clients who want to name multiple people at one time.
Right.
Do you ever get that?
All across the board on all documents.
Okay. Well, what do you typically tell people whenever they want to name multiple people as, let's say, their financial agent?
There's nothing that legally says they cannot. The problems are usually technical. Challenging getting people to be able to be in the same place, make the decisions together. Sometimes it's as simple as the inability of two people to agree on one action. So while it's legally permitted, I encourage people to really consider whether it's a good idea to have two people who could tie up any decision by the inability to make a decision.
Right. So do you normally say that if it's multiple people, we're talking about just a financial power of attorney here. If it's multiple people designated to serve at the same time, do you want them to serve unanimously, by majority consent, or
Well, if it's two,
unilaterally?
it's going to have to be unanimous unless the client specifically designates that either one can act.
Right.
Otherwise, it's going to have to be unanimous if you've just got two. If you've got three, I suppose you could have a majority, but that's going to put a burden on a financial institution to deal with that, and I think that's going to be something that financial institutions are actually going to frown
Right.
upon.
So, what about healthcare? Do you have any
Healthcare's
opinions on that?
trickier. With clients who have multiple children, for example, and they want to name all three of their children, I encourage them to let it be majority in the case of three. If it's two, we can say either one can act, except for in certain circumstances where you might want both of them to have to come to an agreement for an end-of-life decision or something like that.
Right.
But
Right.
where possible, it's nice to encourage clients to allow just one to act, but certainly, especially in a healthcare situation, I think clients frequently want to include children in particular and have an opportunity for everyone to make a choice as far as those kind of things go.
Okay. Good.
But that's also why it's important for them to make their wishes known. As a part of doing that healthcare document, they really need to express what they would want to happen. If they're going to name three people, they really need to make sure that those three people know what they want.
Exactly. And obviously it's a statutory form, so there are going to be gaps in there that don't cover everything. But the best thing to do is communicate. Anytime
Absolutely.
you have any particular philosophies on the provision of healthcare or certain procedures and so forth. Now, what I typically say, and maybe you tell me what your thoughts on this are, whenever people want to name multiple people as their agents for healthcare matters and so forth, I'm always reluctant to do so and advise them that if they do, because there might be a majority or unanimous consent requirement under state law for them to act, that there might be a deadlock in decision making, and that in and of itself creates a decision not to act in a sense.
Right.
And it can impede the provision of healthcare. So you got any thoughts on that? Or
I've done a couple times where I've had clients that really want to include all their children, and so we ultimately give a deadline and a tiebreaker.
Okay.
So they select the one that if there is no agreement after 24 hours on something that is
Time sensitive.
right? That this particular child will be the one who will break the tie, because you have to have someone who can do that in a case of a deadlock when you're talking about a healthcare situation.
Yeah. Okay. I suppose the next thing that comes up quite frequently for me, and I want to get your thoughts on this as well, is when clients move to Florida and they decide they want to leave their documents sort of the same way in terms of the way it disposes of their assets and so forth. And the biggest thing that, becomes an issue is oftentimes the homestead property or the primary residence or something goes away. Well, in any case, if it's not exactly left to the surviving spouse, and there is a surviving spouse, I always inform them that Florida has a stronger public policy on preserving the surviving spouse's rights in certain property. Okay. There's obviously exempt property as well as a family allowance, which are relatively minor in the grand scheme of things, limited to $20,000 perhaps and a couple of vehicles, or $18,000 and so forth. But there are two big things to be mindful of. One, when it comes to homestead, no matter what you do, unless you leave your surviving spouse the homestead property outright or vest fee simple interest, essentially give it to them or into their revocable trust, that surviving spouse is going to have the right to a life estate. So no matter what you left them, that's all void. Okay, the provisions in your will are void unless you left to them outright. And what they get by default is a life estate in that home, and then the children get the remainder. Or that spouse can elect to then take a 50% tenancy in common interest with the remainder beneficiaries. And so that is something that has come up quite frequently.
It's very interesting.
Practitioners here in Georgia often advise their clients, hey, don't worry about it. These are portable. You may have to make some minor changes.
Right.
But if you're not leaving your spouse the homestead property outright to them, that devise is entirely void.
But there's nothing like that. Well, there's nothing like that with regard to property, real estate property in Georgia.
Right.
Your support is sort of something that gets surviving spouse assets when they don't otherwise have assets under terms of a will, perhaps. But there's nothing like that you've described in Florida here. So
that's right.
I can imagine a lot of practitioners aren't aware of that.
That's right. And then the other big piece is your support. You know, here that you talked about, it's sort of this, I don't want to say it's an amorphous concept, but there's no set dollar amount or anything like that, right? And so in Florida, though, there is the elective share, which is exactly 30%. Okay, and the assets you obviously leave to your surviving spouse count towards that 30%. But oftentimes people have this misconception that the 30% applies to just whatever's in the probate estate or whatever's in the revocable trust. Well, it's actually a broader base than just that. It encompasses retirement plans, assets that pass by beneficiary designation.
Okay, that's very interesting. Yeah.
I want to be mindful of all of that whenever you have clients moving down there, just so they understand that, hey, if you're not leaving everything to your surviving spouse, and specifically the homestead directly outright, that there may be some sort of elective share issue if the spouse decides that they're getting less than what they're otherwise entitled to.
So how does that work if they're taking into consideration assets that are outside of the probate estate?
There's a bit of a clawback.
Okay, that's what I was wondering. How there might not be enough assets in the probate estate necessarily, so they could get those assets from outside
Whoever
of
the
probate
designated
assets,
beneficiaries
retirement
are.
plans, insurance, anything that wasn't passing through the estate of a beneficiary could get clawed back into the estate to fulfill that 30% share.
That's right.
Very interesting.
That's right. Well, Claire, do you have any other frequently asked questions that have come up lately?
So I get this from time to time, and it seems particularly as college rolls around for kids in the fall and graduating seniors from high school, is what does my now 18-year-old or my child who's about to leave to go to college, what do they need for estate planning documents? Do they need anything? Do they need a will? Do they need some other documents? And I think every person over the age of 18 should have, at the bare minimum, a financial power of attorney and an advance directive for health care, because once they're 18, the parents aren't able to help them with any financial matters that they might need because there are no longer custodial accounts available. And as a healthcare question goes, you're not able as a parent to see your child's healthcare information or talk with your child's healthcare provider once they're 18 without their permission. And if they're, God forbid, unconscious in the hospital after an accident,
you need a HIPAA authorization.
You've got to have HIPAA authorization to talk to their physician. And hopefully you don't have to make healthcare decisions for them, but you need to be able to do that if they are otherwise unable to make them for themselves after the age of 18.
Yeah, that's great. That's exactly what I recommend too. And oftentimes they ask whether the child needs a will as well, and you and I would both probably say yes, they do need a will. But you know, what I typically see is a lot of the younger adults, they just place beneficiary designations on a lot of things.
They need to make sure they have the right beneficiaries in place.
Right. I would say at the earliest you probably need a will whenever you have children of your own or have any assets really that aren't passing automatically.
Owning property, if you're single and you own property, having a will is probably a good idea at that point.
That's right. Now, do you want to shift gears to a little bit of tax stuff that I've seen lately?
Absolutely, yeah. What are some big tax questions that are coming?
Well, these aren't so much tax questions as I guess the question is more, what are people doing these days in terms of transferring their wealth? And in light of the I guess, volatility in the stock market, the depression in the stock market is probably another way to describe it. Although the interest rates are sort of slowly climbing, the 75/20 rate, I'm still recommending to a lot of people that they consider GRATs, Grantor Retained Annuity Trusts. And do you know how they operate?
I'm familiar, but you can probably give me
Yeah,
some.
to give you just a refresher
The Reader's
there.
Digest version on that.
Okay. So the way a GRAT operates is that the grantor establishes a trust. Oftentimes the grantor remains a trustee, so there's no issue with sort of investment styles and all of that sort of stuff. But the grantor establishes a trust that lasts for a term of at least 2 years. You can go up from there if you want to, but for tax purposes and trying to make sure that you lock in the profits, you probably want to keep it to a short 2-year GRAT term, the minimum. And each year, that grantor gets back an annuity that is based on what they put into it and the 75/20 rate and so forth. Now, that annuity amount can be the same amount each year, or we can have it where it's increasing in the subsequent year. Now, that annuity amount is based on all of those factors we just discussed, going to give the grantor back everything that they put into it at least, plus an IRS approved rate of return. Okay. Anything above that is just a tax-free gift that goes off to the next generation.
And who can the beneficiaries be? Anybody? Spouse or next generation down?
Well, you probably don't want to make it your spouse,
Okay.
obviously, because you get an unlimited gift tax deduction
Right.
for that. But it's usually your children. Clients have been asking me lately on what are the more popular transfer tax techniques and so forth. And the one that I've been recommending regularly these days is a GRAT, a Grantor Retained Annuity Trust. Are you familiar with them?
A little bit, but give me some
refresher?
quick refresher. Yeah.
Okay. Well, in essence, what it is the grantor sets up a trust. Typically, the grantor stays on as the trustee, so they continue to manage the investments of the trust. And according to the terms of that GRAT, they're going to get back an annuity for a number of years.
Okay.
So the term of that GRAT is going to be at a minimum, because it's required by law, 2 years.
Okay.
But of course, you can make it longer if you want to. And so, hypothetically, what will happen is the grantor will put in about $100 or whatever number it is for easy math here. Let's say that it's $100. Well, if the IRS rate of return is supposed to be 4% or something like that, then that grantor is going to get back an annuity in the first year that's going to be $50 plus the rate of return that the IRS has, and then they'll get back another annuity, giving them back the balance of that. Anything above that IRS approved rate of return passes to the next generation gift tax free.
Okay.
Now, you're probably asking who are going to be the beneficiaries of this trust.
Yes.
Who get it at the end of the day.
Right.
Well, you probably don't want to name your spouse because you obviously get an unlimited gift tax deduction. Why go through all the hurdles of setting up a GRAT and funding it and all of this stuff for that? But you can make essentially a gift tax-free gift to your children. You don't want to use your grandchildren typically because there is this, they call it the estate tax inclusion period. It's a technical term, but in any case, you won't be able to allocate your generation skipping transfer tax exemption and all of that sort of stuff. And so typically you just want to make it the next generation, your children. But to the extent that you have stocks and securities, which right now, since we're in either a depressed market or a volatile market, whatever you want to call it, if you don't need the cash flow from those securities right now, you can put them easily into a GRAT. You're at the very minimum going to get back everything you put into it plus the IRS rate of return.
Okay.
Anything above that, if the stock outperforms what the IRS rate of return is, great. You have moved all that appreciation out of your estate and without having to use up any of your gift taxes.
So who's the best candidate for this?
Typically your children.
No, I meant who's the best candidate to, or what is the best candidate to utilize a GRAT? Like what?
If you have, if you have a lot of cash or liquid securities that you don't need.
Okay, so something that's appreciating.
Oh, absolutely. Yeah. But people oftentimes want to put in their businesses or whatever it might be. The problem with all of that is you have to get a valuation every year to determine how much of it you need to get back to yourself.
Right, okay.
And so most people that set up these GRATs are usually utilizing cash or marketable securities and so forth.
And people will do a series of GRATs too, right?
Yes, that's the next point, is that I have clients that will get the annuity from one or two GRATs and then roll those into another GRAT. And so they have these rolling GRATs that end up eventually, if they don't perform, so what? You got everything back. All you've lost are the transactional costs, which might be a few $1,000s. But I have oftentimes in markets that are appreciating over time, you're moving off quite a bit, and you're not having to pay the gift tax or eventual estate tax on it. And so I have clients that have pushed millions off of their balance sheet to the next generation without incurring any of the gift tax consequences.
And this is really good for somebody who doesn't need that income.
Absolutely.
Right.
If this is just some extra stuff that if you're holding on to it right now, you don't want to make a total gift of everything, but I mean, frankly, this is a no-brainer in my view.
Right. So this is something that's good even now when we don't know what's going to happen with the estate tax in a couple of years. This is still a good planning technique because you're not locked into a permanent gift for forever, as opposed to making a gift to an irrevocable trust that's going to be gone forever. This is something that is done on a couple-year basis.
That's right. It's done over. It will take a few years before the gift actually is completed, in a sense, I suppose. But yeah, you get back the cash flow. You're not making a huge gift of it. Now, there is this question of, you asked about, well, if we don't know what's going to happen with the estate tax, do we need to do this? Do we not need to do it? And I would say this is probably an ideal transfer tax vehicle for people that we know for a fact, even if the estate exemption remains what it is right now after 2025, or is made permanent, or whatever the case may be, those are the people that are ideal candidates. For a fact they're always going to have an estate tax no matter what happens. It's only going to get worse for some people that might be within that, I don't know, 14 million to 26 million range right there, and they may say, well, we're not in a taxable estate, right now, but we could be at the end of 2025. And there are other strategies that we probably want to consider for those folks, because if it is made permanent, then there's a possibility of getting a step up in basis that you want to kind of weigh along with moving things out. Because, as you know, whenever you make a gift right now, whatever your tax basis is in the property that you gifted carries over to the donee.
Right.
And so if they have to pay capital gains because they sell the asset the very next day or something like that, it could have been avoided if you held on to it and gave it to them in debt.
Yeah, that's always a toss-up. What's your best tax advantage?
Right. Well, thank you for having joined us today on the show for a discussion of the frequently asked questions that Claire and I regularly see. If you'd like to receive more clips, please subscribe to our YouTube channel or follow us on LinkedIn.
And if you have questions that weren't these questions, you can feel free to reach out to us and request a consultation from one of us or any of our other attorneys that we have at Cohen Pollock Merlin Turner. And you can do that by going to our website, which is cpmtlaw.com.